Welcome and thank you for joining part 2 of Seyfarth's webinar series from our 2024 Cal-Peculiarities publication on California legislative hot topics. All participants are in listen-only mode, but are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. For those interested in CLE credit, an attendance verification code will be read during the presentation. We've recently introduced a streamlined process for accessing and submitting CLE forms. Towards the end of the presentation, you will notice a QR code on the left of a slide and all necessary information on the right. Simply scan the QR code with your smartphone and it will direct you to a digital attendance verification form. Once you've completed the form, you can submit it electronically. This saves time and ensures accurate processing of all your CLE credit. Copies of the webinar recording and presentation materials along with CLE form will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Kathy Feldman to get us started.
Thanks so much. So we're going to be jumping into a review of the key developments that came down in the 2023 legislative cycle. And we are going to kick it off on the next slide with the non-compete agreements. Oh, I skipped right over our agenda. So as I mentioned, our very first topics that we're going to be going over are the most notable developments in the 2023 legislative session impacting employers in California. And after that, we are going to be moving into a review of what is to come in 2024 and some key topics that we're paying close attention to. All right, so now kicking it off with non-compete agreements. I know a lot of these topics are probably pretty familiar to everyone. We've definitely done deep dives into many of them on prior webinars, and I encourage you all to refer back to those. But to start off with non-competes, really what was most critical about this legislation was that it made any contract that is void under California law unenforceable, regardless of where and when the employee signed the contract, whether it was in California or not. And it also codified case law that voided non-compete clauses or agreements in an employment context, regardless of how narrowly tailored, with a very limited exception. So it's definitely going to be a pretty preclusive law that we hope everyone by this point in the year is now complying with. Next slide, please. Another very big development in 2023 were the statewide amendments to California's Healthy Workplaces, Healthy Families Act. This was a really big change in the paid sick leave space that increased the accrual caps, the usage caps, and the carryover caps for California paid sick leave. There is also some preemption provisions in there that impact the local paid sick leave ordinances, of which there are many in California. And it also changed the CBA waiver from a complete waiver to more of a partial qualified waiver. So it's a very, very meaty update, and it's had far-reaching implications, particularly given, as I said, the number of local ordinances that California has, and how this overlaps or differs from some of those. Next slide, please. Another one that was a big ticket item last year is the reproductive loss leave. So prior to this 2023 development, there was a 2022 unpaid bereavement leave law that was put into effect in California. This is essentially an expansion of that law, and it now requires employees to receive up to 5 days of unpaid time when they experience a reproductive loss event, which also includes failed adoption, surrogacy, miscarriage, stillbirth, or unsuccessful assisted reproduction. So it's pretty expansive, and as noted on the slide there, the employees should be able to take up to no more than 20 days of leave in a 12-month period. So it's definitely giving them a lot more time than under the prior iteration of the bereavement leave law, which didn't extend to these types of qualifying events. Next slide, please. All right. So now kind of moving out of the leave space, workplace violence, restraining orders was another big shift with kind of more limited application than we see with the other ones I was speaking about. Prior to this law going into effect, employers had a much more limited ability to seek temporary restraining orders against individuals who had committed violent acts against employees. This law expanded that to allow employers to seek TROs or injunctions if their employees were harassed, as well as suffering any type of violence or threat of violence in the workplace. And there's a very specific definition of harassment under this law, which is shown there on the slide. And so definitely a nice benefit, nice additional benefit for employers and an added layer of protection for employees in the workplace. Next slide, please. So this is talking through workplace violence prevention plans, which was a big Cal-OSHA development in 2023. Since then, there have been several more Cal-OSHA developments this year as well, involving things like indoor heat requirements and similar topics. There is going to be another Cal-Peculiarities webinar that's going to tackle all of those fun developments in the Cal-OSHA space, and that's happening on November 14th. So I encourage anyone with Cal-OSHA questions to tune into that one, which will be led by Patrick Joyce and Alana Marati, our Cal-OSHA experts. But the key takeaway from the workplace violence prevention plan requirement is that it's again very expansive. It applies to almost all California employers with very limited exception, and requires them to create and adopt and implement these workplace violence prevention plans. And the deadline to have those in place was a couple months ago, July 1st. So make sure that you're complying with those. And if you have any questions prior to November 14th, there is also a pretty lengthy blog post on calpeculiarities.com that goes into all of the various requirements and topics that should be included in the plans, as well as the training requirements for them. Next slide, please. So to round out some of our more noteworthy developments last year, we've got PAGA at the top of this slide. Obviously, there has been significant PAGA developments in 2024 as well. What we saw in 2023 was really a small kind of prelude to the more sweeping changes that came this year. I encourage anyone who wasn't able to join our webinar earlier in the month or late last month that really dove into this topic to go back and give that a watch, as well as, again, a very thorough and detailed Cal-Peculiarities blog post on the topic. It is just too meaty of a subject to go over here with everything else we have to cover. But suffice to say, it was a massive overhaul and significant changes were made to PAGA. So definitely something to check out or talk to your favorite PAGA expert at Seyfarth about if you have specific questions on. In addition to PAGA reform, both in 2023 and more recently in 2024, in 2023, other key legislation, as noted here, dealt with the retaliation rebuttable presumption and electronic notice requirements. Those were both new developments in 2023. We don't expect any further developments on them in 2024. We're going to move ahead to the next slide, which talks through a few of our industry-specific bills that came down last year. Again, there was a lot of development in industry-specific spaces. We've given a little bit of attention here to the ones that were the most noteworthy, but there are certainly others that were passed as well. At the top of the list, we've got our airline cabin crew employee meal and rest breaks. That one was passed very early in 2023 and went into effect pretty early in 2023, as opposed to a lot of the other legislation that had a January 1st, 24 implementation date. So if you are in that industry, definitely make sure that that's something that you are complying with. We also saw expansions of certain hospitality employees' right to recall after layoffs related to COVID. That is still in place, even though I know we would all love to believe that COVID has long since ended. It doesn't sunset until December 31st, 2025. There were also changes involving the fast food industry and the proposed fast food council, and new requirements for successor grocery employers in terms of hiring and reinstatement provisions. Next slide, please. And another industry-specific law that we wanted to just give a little bit more attention to is the healthcare employee minimum wage law, which increased wages for all healthcare employees on under 5 separate wage schedules. One thing to note here is that the law initially required implementation on June 1st, 2024, and Governor Newsom signed a bill that pushed that back by 1 month to July 1st, 2024. What that delayed implementation did was it also resulted in that subsequent yearly increases are now going to go into effect on July of each of those years as opposed to June of those years. So just something to note in terms of when everything starts to roll over and those increases go into effect. But otherwise, again, another very meaty topic that we delve into very extensively on the blog, and I encourage you to take a look at that. And with that, I am going to pass it over to Christina to talk about what I'm sure everyone is most excited to hear about, our hot topics for this next legislative cycle.
Okay. Hi, everyone. Thanks, Kathy. So Kathy was revisiting the ghosts of legislative sessions, or the legislative session past, especially pertinent for 2 reasons. Number one, we are at the end of the 2-year 2023-2024 legislative session, and when you're in the middle of a 2-year session, bills can carry over, as some did from 2023 that didn't pass into 2024 to give it another go. That will not happen at the end of the 2024 legislative session. They'll have to start anew with a new 2-year session. Also, it's notable because, as you all know, we put out an updated Cal-Peculiarities book every year, and that's why we're doing this mini webinar series, to give you a preview of what will be in this year's, or is in this year's edition of the book. But because we just had 2 or 3 days ago, this last weekend, the last day for the California legislature to sign, or to not sign, to send bills to the governor to potentially sign or not sign into law, we thought we had to at least give you a preview of what might become law come January 1st, 2025, if Governor Newsom does sign them. And I'm going to refrain from making any political statements as to what else he might be doing with his time right now, with all the political stuff going on in the world. Okay, so here are the key dates out there. So as you can see, we've crossed off the dates that have already passed in the 2024 legislative session. What we have, or I did not cross off August 31st, that just happened. That was a key date. As I mentioned, last date for each house to pass bills on to the governor. The governor now has until September 30th of this month to sign or veto bills that were passed to him. And then all of the bills that we're looking at, provided none have an urgency clause, which we would note for you if they do, will take effect January 1st, 2025. So not as much as recent years, especially because PAGA happened. And as Kathy mentioned, we're not going to talk about that today because it's a whole monster of a topic in and of itself. And happy to provide any of you with a link to the recent webinar, as well as blogs that we just did on that goes in depth. So here is your high-level overview of the remainder of potential new laws that should be on your radar. Number one, falling under the Fair Employment and Housing Act. SB 1137 would include within the classes protected from discrimination by FEHA the intersection or any combination of those characteristics. And I think it's interesting to note what the legislative intent is in this bill. So the bill itself says that its point is to recognize the concept of intersectionality in California civil rights laws. This bill amends not only the FEHA, but also amends the UNRRA Act and amends some education code provisions. And, you know, it says that the intersectionality is a framework that sets forth different forms of inequality and how they operate together, exacerbate each other, and can result in amplified forms of prejudice and harm. So the legislature is trying to get at that goal, and also is saying that it's affirming the decision of the Ninth Circuit in Lamb versus University of Hawaii, and that in turn with that, it often may be necessary to determine whether the discrimination or harassment occurred on the basis of a combination of the factors or protected classes and not just on one protected characteristic by itself. So it's a rather minor change to FEHA. The sections that it would amend are just sections 12920 and 12926 of the government code. Doesn't make a big sweeping change, but it is definitely something that we would need to be aware of if it does change, as it somewhat changes our list of protected classes. The second bill here, SB 1022, would extend the deadline for the CRD, the agency that enforces the FEHA, to file a director's group or class complaint to 7 years. So that's quite an extension for the director to see if it thinks there's this systemic discrimination going on that the director wants to pursue in a bigger action. That has been something that both the EEOC and the California Administrative Agency, the CRD, have said is on their agenda, is to seek out and eradicate systemic discrimination. And apparently the legislature thinks that the CRD should get more time to be able to do that. We'll see if the governor agrees or not. The next one, SB 399. This is something that we've been talking about for a while here. Not new this year, but it is going to the governor's desk for him to consider this year. SB 339 would prohibit discrimination or adverse action against any employee who declines to attend or to participate in, to receive, or to listen to an employer-sponsored meeting or employer communications regarding the employer's opinion about religious or political matters. In other words, it would prohibit employers from saying, come to a meeting where we're going to talk about religious stuff, where we're going to have prayer, where we're going to talk about our political views. Employers would not be able to do that under this bill and would be prohibited from discriminating against or taking any sort of retaliatory or other adverse action against an employee who doesn't want to participate in that sort of thing. It would impose a civil penalty against the employer and would, you know, if this sort of thing happened, would require the employer to pay any employee who does not want to attend for, you know, them doing their normal job but not attending this. We'll see if that passes as well. Driver's license discrimination, SB 1100, would prohibit statements in employment materials, and in the proposed legislation, it is job advertisement, posting, job application, or other material is what they define these employment materials as. So it would prohibit statements in those materials that an applicant must have a driver's license unless the employer reasonably expects the duties of the position to require driving. If, for example, the very reason that the position exists is to drive places, then that would be an exception here. But otherwise, you can't state that the applicant must have a driver's license unless there is an exception. And also, the employer reasonably believes that satisfying that job function using an alternative form of transportation would not be comparable in travel time or cost to the employer. Alternative types of transportation that the legislation contemplates here are using a ride-hailing service, using a taxi, carpooling, or bicycling, or walking. So we'll see what happens with that bill. 2499. You know, when this one first came on the radar, I thought, well, we already have this. But what 2499 does is it recasts and expands the provisions in the law for providing victims of crime time off of work to essentially attend to the consequences of having gone through that. It also recasts time off for jury service. So it essentially removes the jury service time off provisions from the labor code and moves them into the government code so that now they would fall within the enforcement authority of the CRD under the FEHA rather than the labor commissioner potentially under the labor code. So what this bill would specifically do, and this bill is a bit of a meatier one here, it would prohibit discrimination, retaliation, and discharge against an employee who, number one, takes time off for jury service, and that one has the employee needs to provide reasonable notice caveat on it. An employee who takes time off to appear in court as a witness under a court order or a subpoena. An employee who is a victim and takes time off to obtain relief for their or their child's health, safety, welfare. And again here, with reasonable notice, unless that's not feasible. And then there's a whole nother category that applies just to employees of employers with 25 or more employees. And it's a long list there, but the gist of it is the employee is a victim or has a family member who takes time off to assist the family member for various reasons related to a qualifying act of violence. And that's a change in the terminology rather than just a crime or abuse. And here again, there must be reasonable notice unless not feasible. And again, for this one, there's a long list. We're paraphrasing there in the interest of time. As Kathy noted, we're going to have a full-fledged update, I believe. She noted, at least we are going to have it at the end of session, and we'll go into this in much more detail then if it passes. Those are the key provisions, though, as to the prohibitions against discrimination, retaliation, discharge, but there's also a reasonable accommodation interactive process component to this bill, and that is that you must engage in the IPRA for employees who are victims or have family members who are victims of the qualifying act of violence, again, a new term of art, upon request for the safety of the employee at work. And it does have some caveats there as to what is and is not reasonable. If it's something that would pose a risk of harm to other employees, that's not reasonable, and other caveats as well. The bill would allow the employee to use vacation, personal, or paid sick time. It makes an amendment to the paid sick leave law as a result of this. It would run concurrently with FMLA and Seyfarth if it's for the same sort of reason, and the bill specifically sets that out as well. And it would require a new employee notification requirement that employers inform employees of their rights under this. If it becomes law, new law. So stay posted with that one. That one would be one that really would need to be on your radar to make some process and potentially handbook or policy changes if it passes. Okay, while we're talking about paid family leave, at least this one's a relatively shorter change. AB 2123 would eliminate employers' ability to require an employee to take up to 2 weeks of earned but unused vacation before the employee's initial receipt of benefits during any 12-month period in which the employee is eligible for these benefits. This would be an amendment to Section 3303.1 of the Unemployment Insurance Code. Switching gears here a bit, SB 988 is dubbed the Freelance Worker Protection Action Act, and it would require a hiring party, term of art there, not employer, hiring party, to pay an independent contractor on the date specified by the contract, or if not specified in the contract, no later than 30 days after completion of the freelance worker's services. It prohibits making it a condition of timely payment, a requirement that the freelance worker accept less compensation than the amount of the compensation specified by the contract, or provide more goods or services or grant more intellectual property rights than agreed to in the contract. Essentially, you got to go with what the contract says. You can't withhold payment and try to modify the things there after the fact. a written independent contractor contract is required or would be required under this law. It would need to contain specified information, and the hiring party would be required to retain these contracts for no fewer than 4 years. And it would create a private right of action with availability of damages, fees, and costs to the complainant. All right, next. Whistleblower protections posting. The good part about this one is it isn't anything new for employers. This requirement is already in the law, but it now requires the labor commissioner to develop and put this out there for an employer to post. The labor commissioner already does have something out there on this, and in my quick look, I couldn't quite tell if it was 100% compliant with what this new law would require be on the list, but there already is a whistleblower model notice that the labor commissioner has put out. So if this bill passes, we'll keep an eye on it to see if it is revised. And apologies, one correction here. This one has been signed into law, but the new requirement obviously would not go into effect until January 1st, 2025. So it is entirely possible that what is on the labor commissioner's site is what was put out in response to this bill. But again, I just didn't get the chance to double check and make sure that's 100% right, but we're happy to follow up with anyone who has questions about that and confirm. A couple notable bills that failed because, as like with the third one on the list here, AB 2930, we are getting questions. And I think I even saw an article come out that was talking about all these AI bills that are so scary that are pending when they're not pending, at least not the one that would be the most impactful for employers. But to go through them, the Benefits for Striking Workers Bill, SB 1116, this is not new. It was amazing when it was last introduced last year or the year before, I've lost track of time, as kind of something that would have been a huge change, but it didn't make it through then, and it didn't make it through this year either. This bill would have made employees, after 2 weeks of an employee's absence due to a trade dispute or strike, eligible for unemployment benefits under the Unemployment Insurance Code, which would kind of, change the whole bargaining power balance when you're in a strike. The second bill here, AB 2494, would have required all employers to provide employees with a written notice of coverage under COBRA following termination or reduction in hours. So that would have required potentially a change in how things are done upon termination there, even though, usually a COBRA notice is given anyway. And then the third one, the AI bill, automated decision systems. This bill would have, AB 2930, would have regulated the use of automated decision tools in employment pay, promotion, hiring, termination, or task allocation for purposes of determining employment terms or conditions. Whenever I see this bill, Arnold Schwarzenegger and the Terminator pops into my head and his whole "I'll be back," because this absolutely will be back and it's futuristic, just like the Terminator was. So if you're wondering if this is dead, no, we could end up with like Terminator 1, 2, 3, 4, 5, who knows, until something like this does pass. There was some other AI legislation that did pass this year, so it is absolutely on California legislature's radar, just like every other legislature around the country. So with that speed round of what you have to look forward to that we'll go into in much greater depth in our October 2nd webinar after the end of the governor's time to sign bills, here is your CLE code for this session. What you do is you put your smartphone up to it, you scan the QR code, and then you enter in the information here, and voila, you'll get your CLE confirmation shortly. If you don't have a phone handy, you will get this information after the webinar as well, and you can do it then. So don't fret, you don't need to panic and do this in the couple seconds that we have this slide up there. So I'll leave it up just a minute longer, and thank you for joining us. Again, plug the paid, what is it, Kathy? It's leaves updates, not just paid, but all leaves updates coming up next. And then an OSHA developments update after that to round out our California Peculiarities short webinar series. And then, like we said, tune in October 2nd for an end of session legislative update. Thank you so much for joining us.